A debate in City Hall over two proposed bills that would expand renters' rights reached a breaking point last week. Two landlords sued the city, not for the proposed legislation, but for the way it was voted on. This sent the bills back a few steps and will result in some parts of the legislative process repeating again. I'm talking with Aaron Mazel, a housing and community development reporter at WHYY, about this unusual move by opponents of the bills and if this could change City Council's legislative process in the long run. It's Wednesday, March 25th. I'm Abby Fritz, filling in for Trenanery, and we're talking politics. I was super surprised last week on Thursday when it came out that the two bills meant to bolster renters' rights that were meant to be voted on that day no longer could be because of a lawsuit brought against City Council. What the heck happened?
Yeah, I think a lot of us were surprised. It was very last minute that this lawsuit was filed, literally the day before lawmakers were expected to take a final vote on these two remaining bills, part of the Safe, Healthy Homes Act. We had known that there was some pretty strong opposition from landlord advocates, but it still appeared that everything was going to kind of move forward until it came to light that a couple of landlords had filed a lawsuit in Common Pleas Court alleging that the Housing Committee on City Council, which was responsible for advancing these measures to the full council, that they had allegedly violated the state's Sunshine Act, which is basically our kind of open meeting laws, where folks are supposed to be able to kind of see the political process unfold in real time and kind of see some of that deliberation before a vote would happen.
Is that usual for City Council to be sued like this and then kind of have to start the legislative process over?
Yeah, I would say this is like exceedingly rare to happen. The Sunshine Act has been around for a long time. I can say since I've been reporting on council, I haven't seen anything like this happen. Wow. This is not par for the course by any means. So now you have this settlement that the city reached with these landlords. There is no admission of wrongdoing when it comes to the alleged violations of the Sunshine Act or the city's home rule charter. It's just an agreement to kind of start the process over, retrace their steps. They agreed that the bills would go back to committee. There'll be a new hearing, and then it's expected they'll go back to the full council after being advanced for a second time.
So are they doing something different this time around? Because they're saying that, there was something wrong with the process the first time. So is there an additional hearing or something that's going to be available to the public?
Yeah, so this hearing will be a public hearing like the other two hearings related to this set of bills. I don't know exactly how they will run things. My guess is that they will take all public comment first and then take the vote. There was an allegation in the lawsuit that there was a violation that they voted on these bills and then took public comment afterwards. Okay. So that basically the decision was already made. And in the eyes of these landlords, that kind of rendered any public comment pretty moot or just that it wasn't going to impact the process. Right.
Mm-hmm. Yeah.
And so from what I understand is that these they'll have some form of public comment and then kind of go to a vote at the end. I don't know if this will necessarily be like a full length hearing the way that we've seen previously or that you traditionally see on bills, just because a lot of this ground has been covered.
Is it usual that they would have a vote before public comment? Is that something that we could see change entirely now after this lawsuit, or?
That is something that is very common in city council hearings. That is not unusual at all. It's also legally unclear if that is actually a violation of the Sunshine Act. The main allegation in that lawsuit is that before the hearing, basically everything had been deliberated on, everything had been decided. And so by the time the hearing came around, it was just sort of going through the motions.
Mm.
Everything had already been decided. And they say that violates state law, that violates the city's home rule charter.
Okay.
And so whether or not that's true, we may never know. Because the city decided just to settle the same day that the suit was brought. So.
Okay, cool. Let's back it up a bit. Let's hear a little bit more about the bills that are causing all the drama. What exactly are these bills? What's the beef? What are people disagreeing on? Why has this become such a big conversation now?
Yeah, so zooming out a little bit, these are two bills that are part of a legislative package that has three total bills. One of the bills, which creates this anti-displacement fund, that's already been passed and that's all ready to go, and even has funding dedicated through the mayor's housing plan. What's left are a series of provisions aimed mostly at protecting tenants against retaliation from their landlord. You can't retaliate. It's illegal to retaliate against your tenant if you're a landlord. Some of these bills kind of spell out some of the reasons that really are sort of protected in the law, like being part of a tenant association. The main sticking point as far as these bills is this proposal to expand what are called good cause protections, which basically require the landlord to provide a legitimate reason for why they don't want to renew a lease or why they want to terminate a lease under a compromise that was reached before the pandemic. That only applies to folks who have these shorter leases, so under a year or they're month to month. The vast majority of renters in Philadelphia, though, have longer leases. You know, if your listeners, I'm sure, have signed year-long leases, sometimes longer. That's sort of the more standard issue. And as it stands, a landlord can just say, I don't want to renew your lease without giving a reason, which fair housing advocates say is really sort of a tool that unscrupulous landlords can use to cover their retaliation because there's no requirement of the law to spell that out. And so if this was passed, this would expand those protections to everybody. And the hope is that that would kind of nip some of this in the bud. Landlords argue that, you know, this is just going to tie their hands in a major way, which could have major financial ramifications if, for example, they argue if they aren't able to get rid of a problem tenant, they have to stick around. Then other tenants who don't want to deal with that, they leave, they lose that rent. That's sort of the argument. But it's sort of unclear how valid an argument it is. I mean, you talk to housing attorneys and they say that it's really incredibly difficult to prove retaliation, particularly if you don't have a reason that's listed. It's sort of, you technically could make a complaint, but what's the basis?
Because like you said, it's already illegal to retaliate against tenants. So this is just trying to give more of a specific explanation of like what constitutes as retaliation. So it's easier for that law to be upheld.
Yeah, that's definitely part of it. And the other part of it is just to sort of have like equal rights under the law. You know, in every other big city in the country that has these, you know, good cause protections, it applies to everybody. I mean, there's definitely different flavors, I would say, but sort of having it where it only applies to this smaller subset of tenants is unusual. And so this would also bring the city in line with its peers.
I know safe harbor provisions were added after some of the preliminary hearings, and this is a provision that's meant to like protect landlords. So were these adjustments like not enough in the eyes of opponents to these bills?
Yeah, I think that's a fair assessment. You know, part of that relates to part of the bill where it spells out that tenants could potentially, they have the right to sue their landlord if they find out that they didn't have all the documentation and paperwork they needed to collect rent in the first place. And
Mm-hmm.
landlords are pretty freaked out about that because they're concerned that, let's say they didn't have a rental license for 6 months. That means that they could, potentially sue them for 6 months back rent.
Mm-hmm.
And that could be disastrous for an independent landlord, especially if you have multiple tenants doing it at the same time.
Mm-hmm.
I probably don't have to tell your listeners that affordability is a big issue right now. That extends, not only to tenants but also to smaller landlords who may not have that slack. And so
Mm-hmm.
that's also something that's on the table. Hard to know if that's going to be tweaked at all between now and when they might vote on this again.
I am wondering too, like, from the landlord's end, would this legislation potentially affect small time landlords more than maybe some of the bigger, companies in the city that have lots of units and things like that? Is that something to consider, on that side of the argument?
Yeah, I mean, look, the folks that have been lobbying against this legislation, lobbying for things to be tweaked and altered in this legislation, they're all folks who are smaller landlords, which, are mostly who's operating in the city. I think generally speaking, corporate landlords are better positioned to absorb certain things. Financially, whereas an independent landlord with a handful of units, if one of those units gets tied up financially, that could be a problem.
Yeah.
That could be it. That could be enough to push them to, for example, sell their building, which is something that the landlord advocates point out, that there's always this pressure, especially for affordable housing landlords, to kind of go the other direction,
Mm.
because there's more money to be made. And ultimately, they argue that some of this stuff kind of hurts tenants as well, because if they have to lay out more money for some of these things, that could lead to more expensive rent,
Mm.
or could lead them to just turn their units, as I said, turn their units market rate instead of affordable. So I think it's mostly, we're talking about independent landlords here.
Mm. Mm-hmm.
Corporate landlords have their own issues that people have with them. But yeah, I think this is more about the little guys.
Yeah. Aaron, were you at any of the city council hearings that pertained to these particular bills?
Yeah, I covered both of those. Yeah.
I was just wondering because I heard they got kind of heated. I heard there was some very public disputes between kind of both sides of these bills. Do you want to talk about the energy in the room? Because I feel like maybe it lets us in a little bit on how it kind of has gotten to this point with the suing and now this legislative process starting over. What was the energy like?
Yeah, I think people on both sides were pretty animated, and have
Yeah.
been around these issues. These are things that speak to people's livelihoods, their quality of life, both for tenants and for landlords. And so, particularly at the most recent hearing, there was a lot of like crosstalk. There was, at the end, particularly a couple of landlords who were very upset about what had transpired, particularly I think around the fact that they had voted, and then went to public comment, as we were talking about. That's how that was relayed to me by one of the plaintiffs in the lawsuit. I think there's some agreement that both sides, the tenants and the landlords, sort of stepped over the line to some respect, that there was some level of disrespect happening on both sides. But yeah, I think that, like you said, I think that really just speaks to how contentious some of these points are. Some of them which are highly technical,
Yeah.
but in the real world have some real consequence. At least those are the arguments.
All right, we've got more after this quick break.
Hi, CityCast listeners. This is David Plotz. I'm the CEO of CityCast, but I also have another job. I'm one of the hosts of the political Gabfest, Slate's politics podcast. Every week, I get on mic with my co-hosts Emily Bazelon and John Dickerson, and we talk about politics and a lot more about other things that we care about. The Gabfest has been going for more than 20 years because the three of us love talking to each other, and we have an amazing community of listeners. If you like the open-hearted, curious way CityCast approaches cities, I think you'll like the political Gabfest too. Stream it on YouTube or wherever you get your podcast.
All right. You already kind of alluded to this, Aaron, but we did an episode a few months back about renters' rights. The lawyer we spoke to said that, protections could be stronger in Philly. Do you think these proposed bills are trying to address some bigger picture concerns about renters' rights in Philly?
Yeah, I think the main is, from what I gather and talking to people, really the issue here is about trying in some way to better address the widespread fear that a lot of tenants, particularly low-income tenants, feel. And it's a big issue when it comes to discussions around the city's affordable housing crisis, because you have, thousands and thousands of tenants who can't just up and leave if their apartment is in poor condition. These tenants do have rights, but in reality, depending on who your landlord is, it may not be easy to exercise those rights. There's a lot of fear from tenants that if they speak up, if they say something, if they ask for them to repair things that need to be repaired, then they'll just be shown the door or be retaliated against in some other way. And so, while landlords will say, we already got plenty on the books, it's just really about the enforcement, I think there is a feeling among tenants that this would provide some relief and empower them to speak out more than they are. Because, just zooming out for a second, we have a very tight housing market in Philly. And so even people with more means, there's not a lot of mobility. And so it puts even more pressure on the quality of your unit and brings these kind of issues into even deeper relief, because you just can't always have a way out. I think a lot of this is just trying to sort of provide some sense of relief and legal outlet for folks who have otherwise felt pretty powerless at times.
Yeah, I think you kind of hit the nail on the head. I feel like affordability is so top of mind, like in the housing market and in general. And I know, Mayor Sherrell Parker's signature home initiative has been like her big thing that she's gotten through. Was Mayor Parker expected to sign these bills if they had made it to her desk? Was she always kind of in support of them?
Initially, there was some pushback, which is why these two bills were held. The author, Nicholas O'Rourke, Councilman O'Rourke, agreed to hold them in the face of those objections so that there was more time for things to be negotiated. So this has been going on for some time. There have been some signs, some evidence that the Parker administration is sort of on board with this this effort. For example, as I mentioned, the bill that kind of passed last year was to create an anti-displacement fund. There is some funding for that in the home initiative. And then in her latest budget proposal, you also see a proposal to include some funding for a proactive rental inspection program, which is another major piece of this push that we didn't really talk about much yet, which would essentially have city inspectors come out to rentals on a rolling basis, on a regular basis, so that the need to file a complaint and to potentially put yourself in harm's way could be minimized. It's unclear kind of what that program will look like. There's an agreement to create a pilot program of some kind, but those details are unclear at this point.
Yeah, regarding license and inspections, it sounds like some people are unsure whether or not L&I has the capacity to take on another program like that. But definitely, like, all of these topics have been very top of mind. Were these bills expected to pass then?
They were, at least according to O'Rourke's office. I don't think there was ever any doubt that they would pass out of committee, which is a required step to get to the final vote. I think there was, for a time, some concern that maybe lobbying from the landlords might make the final vote more of a toss-up, but it appears, and I've been told, that there was expectation that these were going to pass. Generally, this is a council that's, supportive of housing regulations, housing policy, even if the particulars become, the target of great debate, as we've seen since the mayor has introduced the home initiative. So, but yeah, so this lawsuit, going to your question, was sort of like pulling the rug out to some extent as far as advocates are concerned, before they were getting ready to really celebrate what they considered a major victory.
And my big question about all of this is what was the lawsuit a smart move? I mean, it already passed, in committee. It's going to go essentially through the same process with just, the public comment before a vote as opposed to after. Is anything going to realistically change because of this lawsuit, or did it just kind of delay the inevitable?
I think it depends on who you talk to on that one. I think certainly O'Rourke, and he said this during the last council session, that he views this lawsuit as basically just a delay tactic, that ultimately, everything will happen that was supposed to happen. The people who brought this suit and other landlords say, hey, this is an opportunity to maybe strengthen the bill, maybe get in some more tweaks, so that everybody's kind of feels like they're getting what they want, that it's a true compromise of sorts. Whether that happens, whether anything substantial changes in the legislation, well, I guess we'll have to see.
So what's the new timeline looking like? Do we know anything yet about when these bills could be voted on again, or when there'll be more hearings?
Yeah, so it appears that there will be another hearing pretty soon as next week. I don't know if they'll vote right then. I think that's probably the plan. I know that O'Rourke and his office really would like to get this all taken care of before we really get into the thick of budget negotiations, where the focus is going to be kind of all over the place, because there's going to be a ton of hearings in council, on those subjects where folks are going to come and ask for, various things that will have to be debated. So yeah, we could see this all kind of wrap up in pretty short order, potentially.
All right, Aaron Mazel, thanks so much for talking with me today on CityCast Philly.
You got it.
You can read more of Aaron's reporting for WHYY at the link in the show notes. All right, that's all for today here on CityCast Philly. If you enjoyed this episode about renters' rights, tell a friend, rate the show, leave us a review, and subscribe. Be sure to sign up for our morning newsletter to learn more about what else Philly's talking about. And don't forget, you can support the show and get great perks by becoming a CityCast Philly neighbor at membership.citycast.fm. We're going to be back tomorrow morning with more news from around the city. Bye.